Good morning.
Morning.
Sorry, my speaker wasn't working. I had to restart. How's everyone today?
Good, thank you. How are you?
Okay. Okay, this is our last class. So I know we know all the other chapters, so we only have to go over this one, right? No affirmative?
Yes, Mom.
Okay. All right, let me just take the register. Okay. Just give me your first initial and last name.
Shay, last name Stubbs.
Jeez, Thumbs, okay.
Hello.
Hello, okay.
Melissa Francis.
Okay.
W. Francis.
Okay. And that's it? Okay. Let me see what we usually have. Okay, so only A sounds missing. Okay, then. All right, so last week we would have gone over beneficiaries. And what we said about the beneficiaries, who are they? What type of owners are they in the trust?
Equitable.
Right, they're the equitable owners. What section 83 of the trustee acts provide?
Is that the one that gives them right to information?
Right, and what right they have in the Bahamian context of what right they have to information?
They can request like accounts and things that'll help them to be able to see that the trust is working properly, but they're not entitled to see minutes or any documents that pertain to the decision making of the trustees.
Excellent. Now, what did the Smith case establish for us? What Smith and Rosewood says?
This is a case that
Um,
I'm trying to trigger my memory. This is a case that has to do with information, right?
Right,
So if something is, if it would be able to prove that the trust wasn't administered properly, then it's something that they would have to disclose if a court orders it.
right. So what they call it conducive to the proper administration of the trust? Documents that would be disclosed if it's conducive to the, what would they consider? What the trustee would, what Smith tells you the trustee should consider before they disclose the information to beneficiaries?
The nature of the request,
Uh-huh,
if the information is sensitive or not,
right,
and the reason why I guess they're requesting it as well.
right. And what else?
What it is
Or the
that's
information itself that they're
Right, what they,
requesting.
right. Now, what did O'Rourke v. Derbyshire say about the trust? What they said? The beneficiaries have a what?
they have a right to getting the information,
Yeah, what the right is?
the proprietary
Proprietary.
right.
Right, so they have equitable interest and a proprietary right. Now, in looking at O'Rourke v. Derbyshire, London Dairy Settlement told us something as well. What did they tell us? about the
don't know.
beneficiary having right to inspect documents and all that stuff. They give us 3 points we should look at.
I remember one of the points is they have to have a proprietary interest to see in.
Yes.
I remember
That's
that.
Okay, yes. And what else? The documents they want to see should be in what? In the possession of the trustee as
Oh,
trust.
trustee.
Yes. And what else?
They have to have a right to that information as well?
That's the proprietary interest.
Oh,
but-
okay.
Right,
Okay.
but what they say about what else? The document should contain some information about the trust which the beneficiaries were
But-
entitled to know.
Yes.
Yes. So we know what Smith, O'Rourke, and Derbyshire, and what Sanders and Baudier tells us.
That if the beneficiary, that beneficiaries who are a single beneficiary or a group of beneficiaries who are ascertained as complete as a group and entitled to the property, the interest, entitled to the trust property can
Mhm.
request that trust property title be transferred over to them.
So-
And the trustees are obligated to do so if they all agree.
Right, so they must be first, what they must be?
They must be ascertained and complete as a group.
Something else?
Oh, and they have to be sui juris,
Yeah,
which is requisite my mental and legal capacity.
right. Now, what can the settler do to avoid this happening?
He can put a clause in the trust instrument that says that they can't request.
Right, he
Title-
can put in an express clause, right?
Yes.
Now, what about the common law principle? What does that say about these beneficiaries who can now come in and exercise some type of what influence? What they can do, they can come in, they can now what? Interfere with the smooth running of the trust, right?
Yes.
So what they say about that?
Mm,
They can, the
That-
common law principle allows the trust to run smoothly without
That interference.
from the beneficiaries.
Interference.
Who could do what? Possibly wield some
Inappropriate influence, their
influence,
personal interest,
right? Because then would we consider that trust after that?
a sham.
Excellent. Okay, and what principle, which case dealt with the ascertain the beneficiaries as a group?
That was the Sanders Baudier case.
As a group and certainty of objects.
Oh, I don't remember that.
McPhail and y'all keep saying McPhail. Who's McPhail? McPhail and who? McPhail v. Dalton.
Dalton, yes.
Yes, we talked about this last week. Right, that's going by a couple of chapters.
Oh, okay.
All right, so some of these things will, stick once you repeat it.
Yeah.
Okay, so now we're on unit 13, our last chapter, and it may be unit 14 too, in some books, eh? I don't know if anybody has it as unit 14. Anybody?
No, mine is 13.
Okay,
Mine's just 13 as well.
okay. So after completing this unit, we should be able to understand the ways in which a trust may be liable for breach of trust, understand the law relating to a trustee's duties, and understand the rights of beneficiaries to bring an action against the trustees for breach of trust. Okay, we have a very short chapter. So the first person can read up to point 10 after types of breach of trust. Who will start us off?
I can start.
Thank you.
A trustee owes duties of care and skill in carrying out their duties and responsibilities as a trustee in the administration of a trust. Joseph Hayem versus Citibank, 1987. The trustee must act honestly and in good faith in the executing his duties to the beneficiaries and the trust. Ordinarily, if a trustee performs his duties strictly in accordance with the law and the terms of the trust instrument, he should never be in breach of trust. A beneficiary, as equitable owner of trust property, may bring a personal claim against the trustees for breach of trust of the fiduciary and other duties owed to him and the other beneficiaries. Target Holdings Limited versus Redferns, 1996. In order for there to be a breach of trust, there must be a breach of some duty. The damages recoverable for breach of trust in equity are the same as the damages recoverable for negligence or breach of contract in common law. Whilst compensation for breach of trust, which is an equitable claim, is the same as a claim in common law where damages are awarded. Bristol and West Building Society versus Matthew, 1996, sorry. The beneficiaries must prove that there was some loss occasioned by the breach of trust. Nestle versus National Westminster Bank, 1993. The measure of liability for breach of trust is the loss, direct or indirect, caused to the trust, which is normally compensatory rather than punitive. The onus is on the claimant, in this case, the beneficiaries, to establish the causal link to the actions and loss suffered. Re Miller's trustee in 1978.
Okay, so we have the trustees. The trustees owe a duty of care and skill in carrying out their duties. And what we say about a professional trustee, he's held to a what standard?
A higher standard.
Yes, because he's selling himself to be this professional and knows what he's doing. He must act honestly and in good faith. So that is what? What type of duty that is when you have to act like that? In the best interest of the a fiduciary duty, right? Yes.
Yes.
And once he performs his duties strictly in accordance with the law and the terms of the trust, he should never be in
breach of trust.
So what he has to protect him in that instance from the trustee act, what we have? Once he performs his duties, what he has? He can do what?
He can insure against.
Yes. And what section that is?
If I tell you, I lie.
Section 23?
No,
No,
remember we
no,
scratched
no.
that out.
Oh, so 24 then.
24.
Yes, 24, right. So section 24 tells us he can do that. So the beneficiary is the equitable owner of the trust property. And as a result, he can bring a personal claim against the trustee for breach of trust. So this claim is not against, he's doing it personally. So how does that affect the trustee when you bring a personal claim against me? He's bringing a personal claim against the trustee. So that's directly against the trustee, as in between him and the beneficiary, eh?
Yeah.
So now this trustee could lose his stock. So that's why he needs that insurance, eh?
Yeah.
And he only is protected by that insurance once he performs his duties.
In accordance with the law and the trust insurance.
Excellent. So, and the claim he can bring is for breach of trust of any fiduciary and other duties owed to him. Give me some duties the trustees have. Y'all remember what section, what unit y'all dealt with the trustees' duties? Y'all remember the duties?
I don't remember the section, but would
Y'all
one of
remember
the
the duties?
You mean management duties? Like, you mean like
What duties, what type of duties? Tell me what all you have.
management duties,
Uh-huh.
administrative duties, duties of
Uh-huh.
and duties of propriety.
Right. Can he pass on these duties?
Some, yes, like investment and stuff like that.
Yeah.
Now, remember the
delegate.
difference between power and duties. The
Um,
duty is what type of duty this is? Duties are fiduciary, right?
mhm.
As between only the trustee and the beneficiaries. Can I pass my fiduciary duties on?
No,
What I can pass on or delegate?
the powers.
Yes,
the-
you can
Powers.
delegate your powers. So your power to invest your power, but your duties
Okay.
are fiduciary, as in between you and the person who you have that duty to.
Okay.
Okay.
Okay, so now we have compensation where there's breach of trust. You can now recover some damage for negligence or the breach thereof. Now, in common law, you have damages. We have compensation for breach of trust, and that is equitable, eh?
Mhm.
So it's the same as common law, but it's now compensation as compared to damages. So you want compensation. So compensation is what? Not punishable, eh? You have to pay me instead of you punishing me. That's what the liability. So the measure of liability for breach of trust is, what is the measure of liability? Is the loss, direct or indirect, caused to the trust. And that is compensatory instead of it being punishable, punitive. And who has to prove that there's a breach of trust?
The beneficiary.
Right, so the beneficiary have to prove that there's a breach of trust. And how can he prove this?
They have the link
He has
to
to,
the
he has to
loss,
establish the,
the link of the loss suffered to the actions that caused the loss.
right, so he has to prove the cause, how the link is, how is this link is established to show the actions of the trustee has caused the loss suffered by the trust. Okay, any questions on that section?
No, ma'am.
Okay, let's move on to types of breach.
Types of breach of trust. Breaches can range from serious misconduct, misappropriation of trust funds, to innocent breaches, failure to follow directions in the trust deed. Examples of other breaches are the wrongful distribution of income or capital by a trustee, the incorrect exercise of a trustee's discretion, not distributing income or capital as required by the terms of the trust, improperly selecting and supervising agents, misappropriation of trust funds for a trustee's personal expenses and benefit, failure to obtain the relevant consent as required by the trust instrument, purchasing trust property without authorization from the trust and/or beneficiaries, unlawfully profiting from the trust, investing trust funds in unauthorized or unsuitable investments, failing to account to the beneficiaries.
Okay, so we have possibly breaches of trust by the trustee. And one is wrongful distribution of income or capital by a trustee. So what in the wrongful distribution of income or capital, who he may have distributed to wrongfully? What may he have done? What we say? Right, so he would have distributed some income, whether he's distributed income or capital to one of the beneficiaries. So supposedly he may have issued capital income to a income beneficiary or vice versa. Or he may have given out, he may not have considered all the surrounding circumstances. What we say before he can make distribution, he has to look at what? What we say about him making these considerations as to where he has the discretion to pay out, right?
Yeah.
And what he has to do?
consider if it's in the best interest of the beneficiaries of the trust.
Right, so he has
present
to,
and future.
he has to consider the trust and all that, right? To see
Yeah.
whether at this time he can make this distribution. What else he has to do? We are a guide as to what we can do. What we say about these income and capital? Remember, we talk about this.
Yeah,
Remember that?
yeah.
Okay, now we jogging your memory. So what they must do?
I know.
This must be our first unit we deal with it. Y'all forget that? That too far back?
It looks so.
And I think this is where it becomes tricky when you have to keep
Tying it back.
connecting the dots. Yeah.
Right, so that's why I say you have to keep tying it back so that you, because remember we expanded on what you would have summarized from the beginning. So now when you expand, now you're supposed to be putting meat on your bones. And as you put the
Mhm.
meat on, you're still supposed to remember where the bone is. Because now it's only tying back to the skeleton you have. Now you're just putting meat on it. Because now you have to remember how to link these together.
Mm.
What do we say about that? We talk about them, how they must decide how they're gonna give out this money.
Would this be thinking in terms of expenses? You have to consider expenses before you could give out.
You have to consider all that. So we have different circumstances in which he must decide how he's gonna now pay out this money.
Yeah, I kind of feel like there's a lot of things they have to think about, what the expenses that the trust has, what the
Mhm.
instrument says,
Right,
who should get what, if the needs of the beneficiaries,
yes,
if it's gonna make sense for the long term life
because
of
they have to
the,
consider all of the beneficiaries. They may have some financial, this may be set up for financial interests of the beneficiaries. We have to decide whether it's a capital or income, so he can wrongfully distribute if he's putting it where it shouldn't be, or he may take a big chunk out of the trust. Suppose he advances, what does he do if he advances a large payment or distribution? Who gets advancement? Which beneficiary gets that?
Capital beneficiary.
Yes, and who gets appropriation?
So,
I can appropriate some funds.
Income beneficiary, no?
So the income beneficiaries get it, right?
Right.
So if I decide where I'm advancing, when I advance, that's a big business I do. And I might say I buy a house for one of the beneficiaries. They may say, no, you shouldn't have bought that because at the time the trust wasn't in a position to purchase that house, and you would have done it to the detriment of the other beneficiary. So that could be a wrongful distribution, eh?
yeah.
You
Okay.
see, that's what that is more or less. So I'm trying to just draw you back into what we were talking about earlier in the trust investments. What
Okay.
about the incorrect exercise of a trustee's discretion? Where he can incorrectly exercise that? Would we talk about him having this, what what type of influence these people could have over him? The beneficiaries?
I guess he has to make sure that they don't have the inappropriate influence to
Yes.
cause them to do
Yes.
what they want thing.
Right, so he may just be a puppet, eh?
Right, okay.
Not distributing income or capital as required by the terms of the trust. Again, he may do something outside of what is established clearly in the trust, what he should have been doing. And he may have done, distributed capital where he shouldn't have, or income where he should not have had. Improperly selecting and supervising agents. Would we talk about that when we talk about him doing that?
Yeah,
He select, and then he failed to supervise or likewise,
Supervise and review.
right, or likewise, he's not done his proper research in selecting an agent and causes the trust to lose big time, eh?
yeah,
Misappropriation of trust funds for his own personal expenses and benefit. That's clearly a breach, eh?
yeah,
Yes.
Because what he has to do, what the trust, what is provided, he can provide a clause in there for him to be what?
remunerated for
Yes.
Remunerated.
And the trustee act provides that clause as well, eh? What section that is? Y'all put a little star there so y'all could put that section, okay?
yeah.
Okay.
Thank you.
Failure to obtain the relevant consent as required by the trust instrument. Who he needs consent from to do certain things. Let's use an example, what we talked about lately,
A protector,
right? Or we call them a who?
a power holder,
Excellent. A power holder may have the power to do what?
authorize certain actions that the trust will take.
Right? On investments, eh?
Yes,
So before he can make any investments, he needs that what?
authorize,
Approval,
Yes, he
consent.
needs their consent. Purchasing trust property without authorization from the trust and or beneficiaries. Can he do that?
you mean as the trustee themselves buying something that the trust owns?
Yes.
No,
What they say that is? The trustee, that's a what?
that's a breach.
Right? Because they call that a what?
Yes.
A disability, right? You remember that? You all remember reading that? The trustees cannot purchase property.
Yes,
They call that a disability more than anything else, yes?
yes.
Unlawfully profiting from the trust. What case reminds you about profiting from the trust? Secret profit, you all remember Boardman v. Phipps?
Which one?
You all remember that? You all remember that case?
I wanna say, yeah, I'm trying to remember what the case said.
Where
the
they
name-
can't make a secret profit from the trust? Boardman v. Phipps.
Was this a case that the trustee rented the property out to someone and was collecting the rent?
Boardman v. Phipps, let me see. Boardman, he used his position to get profits from the trust.
I'm sure I know that.
This was in your trustee remunerations, unit 7.
Yeah,
Yeah, I think that's where the person standing in a fiduciary position.
Right. And fiduciary is what the trustee is, eh?
yeah,
What about investing trust in unauthorized or unsuitable investments?
I don't make
Without-
sense.
That would be like what?
Investing, maybe there's something in the trust that says not to invest in a particular area, or maybe something that is in competition to the trust
Right.
Right.
businesses.
So what case talks about that? You all remember that? where those fellas was really upset that they were selling coal and then the fella went into something.
Right, the coal mine.
It's called,
Yeah. You remember it?
Yeah,
What it was, what the case was?
I can tell you right now.
You see how easy it is when you remember people's business?
Yeah.
Cowan Scoggle case.
Excellent, excellent.
Mm,
All
okay,
right. Or failing to account to the beneficiaries. What did we say about that? They have to account, right?
Yes. That's
They even have to keep some records for how long?
5
Up.
years.
5 years.
5 years,
A minimum of 5 years, yes?
a minimum,
Yeah.
okay.
Yes. Okay. Let's continue where there's a breach. Any questions before we move on?
No, ma'am.
So now you see how we break down 10 points and we could understand it without having to regurgitate what is in the book. We know
Yeah.
we know what is the background to each one of these points, eh?
Yes, ma'am.
Okay, so that's how it'll make it easier for you when you could tie things back. Okay, who's gonna read next?
Starting from the remedies.
Okay, you know, my book may be different from yours. Whatever comes after our points.
Okay. The remedies available to the beneficiaries for breach of trust are: 1, an injunction; 2,
Okay, y'all don't, sorry. Before you move on, y'all don't have where there's a breach of trust, all trustees will be liable?
A few paragraphs down.
Okay, so they have it mixed up. Okay, go ahead.
okay. 2, an action against the trustee for loss suffered. 3, a proprietary remedy to recover trust property. 4, an action against those who have received trust property. A beneficiary will bring an action for injunction to restrain the breach by the trustee. In Bruto versus Sanders, 1950, and then 2 all ER 193, an injunction was granted to restrain a sale of trust property for a price lower than offered by a prospective purchaser. In Fox versus Fox, 1870, the court granted an injunction to rescind trustees from distribution of an estate contrary to the provision in the trust deed. However, the main remedy commonly used by aggrieved beneficiaries is to sue the trustee personally for any loss to the trust caused by their breach of trust. An action against a trustee for loss suffered due to a breach of trust is normally a personal action against the trustee. This legal remedy must be pursued before any proprietary remedies can be made by the court. Read Dimlock, 1948. In general, a trustee is liable only for his personal breaches of trust and not for his co-trustees. However, a trustee may be liable for the defaults of his co-trustees if he was himself at fault by allowing the breach or not supervising the co-trustees. Such a case was seen in Bahin versus Hughes, 1886, where the trustee allowed a matter to remain in the hands of a co-trustee without inquiry. There are no vicarious liability in the law of trust, Section 36 of the Trustee Act. Where there is a breach of trust, all trustees will be liable since liability is joint and several, which means that any one trustee can be held liable for the loss caused by the breach of trust. Attorney General versus Wilson, 1840. However, there are circumstances where an individual trustee has a particular duty and responsibility and may be liable for a greater contribution for loss caused by a breach of trust. To ensure that each trustee pays his fair share of the loss, a contribution or an indemnity may be claimed in certain circumstances by any of the other trustee.
Okay, let's stop there. So we have remedies available to the beneficiaries for breach of trust, and they are injunction, an action against the trustee for the loss suffered, a proprietary right to recover trust property, or an action against those who have received trust property. So in the injunction, we can now stop you from doing something that would now be detrimental to the trust. Because if you already sell the property for a price lower than what it's actually valued at, there's no recovery from that, eh? It may be that you've already sold it, you don't have no money for me to recover, so let me stop you and be able to sell the property. Now, you think homeowners could get an injunction against the banks when they foreclose it on their properties and sell it for pittance on the dollar? What you think about that?
I want to say no.
So they have
But
something now, I think they put something in place to protect the homeowners. They have some protection now in the law that would not allow their properties to be sold at such a far less a price, because you know before
they would just
homes-
sell it. So it was
yeah, they were
owed to the
selling
bank.
it really, yeah, they didn't care that all they were doing was recovering their money, eh?
Right.
And so at the end of the day, your property may have been valued at 200,000 and all they were looking at is, I just getting my 50,000, which you owe me. So you get a fire sale more or less on these homes that people would have invested their life savings in. So likewise with the trust, the trustee could be selling it at a lower price for his own gain. He may be selling it to a friend of his own, eh? So let me stop you from, so that's a remedy I have available. What about if you sell it now and I didn't intercept or stop you before you were able to do it, I have an action against you for the loss suffered. So against that's compensation. So I want the difference, what I could have gotten as compared to what you sold it for. So if the house was for 200,000 and you sold it for 100, I'm suing you for the 100,000 that the trust should have gotten. Proprietary remedy to recover the trust property. So now I want to recover it because I have a right. I want to recover the property that you have now sold. I have a right to that property. Let me recover the trust property that you've given away. And then I have an action against those who have received the trust property. If I can show knowingly that you were a part of this conspiracy to defraud the trust, I will now I would now sue you as well, make you a party to the action to recover whatever you would have received. If you've already gotten rid of it, I want the compensation. So it's not punitive, it's compensatory. So I want to get my monies back. So the most common, where there's a breach of trust, they said the liability may be joint and several, eh? Where we have, there's co-trustees, especially in the case where the trustees allow their co-trustee to run unsupervised without ensuring that they knew something was going on, but they never said anything. So they're just as liable as the trustee who would have done the wrong to the trust. So Attorney General V. Wilson tells us that, eh? Now, is there vicarious liability in the trust? No, because there's no reach beyond to get at the employer, employee, or saying somebody else is responsible for the actions of another, but they can now sue them. They're joint and severally liable. Okay. Now, where does an individual has, well, there are circumstances where the trustee as an individual has particular duties and responsibilities and may be liable for a greater contribution of the loss caused by a breach. So in the case of a co-trustee, and the trustee who would have allowed him to be unsupervised, notwithstanding I'm suing both of them, one would be responsible for the greater contribution. So in that instance, in order to ensure that the trustee pays his fair share of the loss, a contribution or an indemnity may be claimed in certain circumstances by the other trustees who would now be jointly and severally liable. They would now make a claim of contribution or an indemnity against the full loss and say they're only responsible for so much of the loss, where they've allowed this co-trustee to go unsupervised and allow them to do as they see fit, or where they didn't. In the case of them being co-trustees, is only up to the point where I'm responsible for. Any questions?
Is a co-trustee, is that a common thing? Does that happen a lot?
Well, you know, sometimes when I'm choosing a professional trustee, I may ask for one of my friends to be a co-trustee. It's not usual, because usually they'll plug in a power holder or protector.
Okay,
And then most times, professional trustees don't want to be co-trustees with someone else, because then there's this liability that will occur.
okay,
So it's not that often you would see it. They would rather the powers be within the trust, but they don't want to be jointly and severally liable, especially when they're strangers or where I am holding it in a professional capacity. Co-trustees may be between friends, but not, usually they don't want to be co-trustees, especially you would have two professional trustees being co-trustee. I don't know that that would work out so well.
mhm, all right.
All right. So what they say about, okay, I think we did read Diplock. What read Diplock says?
But the beneficiaries must sue the trustees personally.
Yes, so that's a personal, the aggrieved beneficiaries sue the trustee personally before any proprietary remedies can be made. So the main remedy used by aggrieved beneficiary is to sue the trustees personally for any loss caused by their trust. And then then they can go after the other remedies, but sue the trustee and then the other things will come. Okay, go ahead. Who's next? Or who continue for us?
That'll be me.
Okay,
Where we starting from? Sorry.
okay, I have as mentioned, I don't know if
Yes.
that's, okay,
As mentioned.
It's a new trustee, the bottom of the page.
okay,
All right, so that's the next page for me. A new trustee is not liable for breaches of trust committed before he took up his appointment. However, he is under a duty to familiarize himself with the business of the trust, including examining the trust documents and books of the trust. If a breach is discovered, the new trustee has a duty to take steps to obtain redress for the trust estate. A retiring trustee remains liable for any breaches committed by him during his tenure of office. However, the trustee is not liable for breaches by his successors unless he had knowledge that the breach was likely to occur, or that
okay.
breach.
Go ahead.
Go on, okay.
Mm-hmm.
As
Order.
mentioned,
No,
men-
you finish that one then.
okay, yeah, I finished that one.
Okay, what we say when you're taking over a trust, what you have to do?
Familiarize yourself with the trust.
Right, because you have to ensure that you're covered for any breaches that may have occurred. So you usually want to get what from the trustee that's left before the retiring trustee, or the one, what you want to get,
Notification?
or what you getting from them?
All the documents.
Don't you get an indemnity?
Okay,
Don't you
Oh.
ask them, don't you all remember that?
Yes.
yes,
Yeah, so you get an indemnity, so you make sure to search, because if you take it on without thoroughly looking through this, you may now find yourself in the middle of some, what?
Legal
Auction,
battle.
right? You don't want no auction for breach of trust where you would have continued in the breach, not realizing you should have read over the documents, and this shouldn't be happening, eh?
Mhm.
So first of all, you familiarize yourself with the documents. What they say about the retiring trustee, would he be free from any breaches that occurred under his watch?
No.
No,
No, he's still liable.
Yes, okay. Go ahead.
okay, so, as mentioned previously, section 24 of the Trustee Act 1998 provides trustees with the opportunity to insure themselves and their employees and pay insurance premiums from the trust fund for liability and administration of a trust, except for a breach of trust action. The Trustee Act 1998 also gives the trustees certain protections against liability for loss suffered by the trust due to the agents or their own actions, provided certain conditions are met and the trustees acted honestly, reasonably, and in good faith.
What example we use for that one? Remember
mean?
when they selected the agents?
So I guess if you select an agent that everything points to them being capable
Right,
and you were still managing and supervising what they were doing, but they still did something untoward.
uh-huh. So they would now be protected, right?
Yes.
Remember, we put a star, so y'all could tell me about that section? What that section is? Y'all find it here? Where it give you protection for loss.
I don't know.
You remember that now, or you still don't remember it yet? So put the star there so y'all can remember, y'all still looking for that section.
Okay.
Okay, go ahead.
A trustee who is liable for breach of trust may seek some relief from liability if the terms of the trust instrument allow him to do so. He is indemnified by the beneficiaries,
Mhm.
or there has been some act on the part of the beneficiaries in which they have participated in the breach or in effect waive their rights to sue for breach of trust due to some collusion with the trustee.
Mhm.
Arbitration. Although legal actions for breaches of trust are normally settled by courts, Section 18 of the Trustee Amendment Act 2011, which subsequently amends and adds a new section 91A to the Trustee Act 1998, allows the settlement of trust disputes or the determination of complex trust administration issues through arbitration, where the trust instrument makes such a provision for arbitration. Issues such as breaches of trust may now be settled through the alternative dispute resolution mechanism of arbitration rather than having to be resolved through costly, time-consuming, and fairly public trust litigation in the courts. The decisions from trust disputes which are referred to arbitration and determined in an arbitration court are contractually and legally binding on the parties connected to the trust, as if they were parties to an arbitration agreement. Such disputes, when referred to arbitration, are governed by the relevant provisions of the Trustee Amendment Act 2011 and the Arbitration Act 2009.
Okay, so we have the arbitration section. And arbitration is now Section 18 of the Trustee Amendment Act 2011, which now adds a new Section 91A to the Trustee Act 1998 and allows for settlement of trust disputes or determination of complex trust administration issues through arbitration. And what is important about this? Only where the trust, what?
Instrument makes such a provision.
Right, so only where the trust instrument makes such a provision for arbitration. So usually they have arbitration clause in these trust documents, eh? They usually put that in there to cover themselves because most times they don't want the business to be out there in the public domain. So in that instance, where they now put that in there, we can now use that section. And these decisions are what? They are contractually and legally binding on the parties. So they have to adhere to whatever the ruling is made out of the arbitration court, as if they went to court. And they are governed by the provisions of the Trustee Amendment Act 2011 and the Arbitration Act 2009. So usually you make sure that the arbitration clause is in there, and then this will kick in. Section 18, which inserts that section 91A. Now remember section 6 of the Trustee Act, we talked about this when we were talking about investments. You remember section 6? Now it's my page 72, but I don't know what page it is for you. This is in unit 11, trust investments. You're looking section in unit 11.
So that would be our page 87.
Okay, so you all have section 6 and you all have section 13, right?
Yes, at the bottom of page 87.
Yeah, so you all have all those sections to help you with being protected against liability, eh?
Okay,
Yes?
Yes.
Okay. So you have to put your stars and try to put those sections there. Okay, we on the self-assessment questions. Any question before we move on?
Yes, I have a question.
Go ahead.
I was looking while we were reading, section 30
Mhm.
talks about employing agents, and then
Section 30.
30,
Uh-huh.
yeah, so the trustee act, and then it says in subsection 6 that trustees making reasonable efforts to satisfy themselves.
Your thing going down.
Sorry.
Hello?
Trustees who make reasonable efforts to satisfy themselves that an agent has appropriate knowledge, experience, and integrity shall not be chargeable with breach of trust.
Right.
Is that a section that we should be using?
So on where that covers you? Where that covers you?
Employing agents.
Right. And also what section we say deals with that? What you just looked at?
6 and 13.
Yeah, so now you could put a star on 30 as well, eh?
Okay. I'm just trying to make sure I'm putting it all together.
The power to employ agents, power to delegate.
Okay.
Okay. Any other
That's
questions?
my question. Thank you.
Okay. So number 1, the trustee must act blank and in blank in the execution of his duties to the beneficiaries and the trust.
Honestly and in good faith.
And where we'll find that answer?
Page
97.
Everyone has it?
Yes.
Okay. Number 2, a beneficiary as equitable owner of the trust property may bring a blank claim against the trustees for breach of trust of the fiduciary and other duties owed to him and the other beneficiaries.
Personal,
Say it again,
personal
and where we'll find that answer?
on my page 97 for me.
Everyone has it?
Yes.
Yeah.
The measure of liability for breach of trust is the blank, direct or indirect cause to the trust, which is normally blank rather than punitive. Where we'll find that?
Also on page 97.
Mhm.
Paragraph 4.
And what is it?
Right.
What is the answer?
Loss and compensatory.
Statutory.
Okay, what are some types of breach of trust?
A lot. Wrongful
Where we'll find the
distribution,
answer,
page 97 and 98,
Right.
and what that is points 1 to
10.
10.
1 to 10, okay. Give me one such breach,
Unlawfully profiting from the trust.
okay. Number 5, what are some remedies available to the beneficiaries for breach of trust? Where we'll find that answer,
Page 98.
98.
okay, give me one remedy,
An injunction.
Injunction.
excellent, okay. Number 6, the main remedy commonly used by grieved beneficiaries is to blank for any loss to the trust caused by their breach of trust.
To the trustees personally.
Personally.
Okay, and where we'll find that?
Page 98.
Okay, blank of the Trustee Act 1998 provides trustees with the opportunity to insure themselves and their employees and pay insurance premiums from the trust fund for liability in the administration of a trust, except for a breach of trust action. Where we'll find that answer?
Page 99.
9.
And what is that?
Section 24.
24.
Excellent. All right. The Trustee Act 1998 also gives the trustees certain protections against liability for loss suffered by the trust due to their agents or their own actions, provided certain conditions are met, and the trustees acted blank, blank, and blank. Where we'll find that answer.
Also on page
99.
99.
99, and what is that?
Honestly, reasonably, and in good faith.
Excellent. A trustee who is liable for breach of trust may seek some blank from liability if the terms of the trust instrument allow him to do so. Where we'll find that answer.
Also
Okay.
page 99.
Okay, what is it?
Relief.
From liability. Number 10, although legal actions for breaches of trust are normally settled by the courts, blank of the Trustee Amendment Act 2011 allows the, okay, my page went off. Y'all could finish read the question.
The settlement of trust dispute or the determination of complex trust administration issues through arbitration where the trust instrument makes a provision for arbitration.
Okay, and where we'll find that answer?
Also page 99.
What it is?
Section 18.
Of the Trustee Amendment Act, yes. Okay, so that's the last question, eh?
Yes,
So we
sir.
know we have arbitration clause, it has to be inserted. And then section 18 will kick in of Trustee Amendment Act 2011, which inserts section 91A in the Trustee Amendment Act, in the Trustee Act 1998. We know that we have insurance that covers the trustee for breaches, but those breaches can, what type of breaches? What is that section 24? Provided he does what? Performs his duties strictly in accordance with
But the trustee.
The trustee
the law and the
agreement.
terms of the trust instrument, eh? He will
Mhm.
never be.
Yes.
He'll be. Who pays the insurance in accordance with section 24?
The trust fund.
Yes, it comes from the trust fund. And give me an occasion when the trustee could be liable for breach of trust?
Improperly selecting agents and supervising what they're doing.
right? And what remedies may I have as a beneficiary for breach of trust?
Sue personally.
Sue personally, what is the remedy available?
An injunction?
An
Injunction.
injunction. Right, what is the measure of liability for breach of trust?
The loss caused to the trust,
Direct or?
indirect.
Direct.
And what type of, what I get?
Compensatory rather than punitive.
And who is the onus on to prove it? Who?
The
who-
beneficiary.
Excellent,
Beneficiary.
excellent, excellent, excellent. Okay, I think we've covered that. We've covered, this was an easy chapter, eh? You all know this chapter back and front now, eh?
I think so. So I have a question, please.
Okay.
So if the trust instrument doesn't speak to arbitration, then that's when you would take everything to court, or do you still have to get a court order to begin arbitration?
So, if there's no arbitration clause, then the parties have to decide to go to arbitration. Otherwise, they may go to court instead, eh?
Okay,
So if there's nothing in the trustee, on the trust instrument that provides for arbitration, then this section won't kick in. And so
okay,
now the parties can agree that they will arbitrate, or they can go ahead and start a nasty court action.
okay,
Okay.
gotcha. Thank you.
All right. Any other questions? No? Okay, I think you all have a review session. I'm not sure, but I think so. Yes?
Yes,
Okay.
Yes.
I think Ms. Archer will do the review for you.
yes,
Okay.
Okay. So you all understand units 10 to 13 well, right?
I think so.
Good. Excellent. Yeah. All right, so do well, and I hope all of you pass with 100%
Thank you very much.
Thank you.
for being engaging.
Okay,
But take care.
all
Okay,
right.
Thank you.
bye.
Bye.
Bye.